while I text Felicia, so what she was basically saying is that criminal law for, okay, I'm gonna wait till she disconnects. I'm not gonna talk over her.
Parts apply to the packet that we have. And
All right, well,
oh, it's oh,
now, Felicia, try saying something now.
something now.
Now you're good.
I'm still gonna try to switch over.
Okay.
I don't know where you lost me though, because I was kind of talking about criminal law.
Lost you right after your like criminal law is different from contracts and like property. So we lost
because it's
you.
more interesting.
Yeah. So we lost you quite a ways ago.
Oh, okay. So criminal law is different from the other parts of being in law school. Full-blown lawyers always liked talking about criminal law, even if you don't practice it, because it's just the facts are more interesting. And as you guys saw, going through the homework, we get interesting facts in criminal law where in other areas they're not as interesting. So I was talking about that and how it's different. And then, so we're going to go through the homework and then talk about how some of these laws could apply to your mock trial packet and mock trial facts. That'll be at the end. So as we go through these, I wanted to okay, I'm gonna have to log in somewhere else.
Okay, well, Felicia, are you gonna try logging on to something different?
Mm-hmm.
You do keep cutting out. All right, I'll take over while you.
Do you want to just start with the first question and then
Yeah.
I'll go back on?
Sure. All right, so you guys had two handouts this week. You had the video handout and you had the actual homework. The homework had like real questions, where the video handout had like short little fill in the blanks. So if everyone is good on the video handout, we're just gonna jump right into the week 2 homework about Jasmine and Zeke. So if you guys want to pull that up, I will quickly read through the question and then I'm going to call on someone. Actually, I'm going to ask you guys what you think the answers will be in chat. And then I'm going to ask someone from chat to tell me why they think the answer is what it is. All right. So question number 1 is about Jasmine and Zeke. They live in the same apartment building. And Jasmine asks Zeke for a favor. She tells Zeke that she loaned her stereo to Fabian and she wants it back. Jasmine says that Fabian's out of town and he has given her permission to go to Fabian's house and pick up her stereo. She asks Zeke to go get it for her because the stereo is heavy and that she can enter Fabian's house through the unlocked back door. Zeke doesn't know this, but Jasmine was not telling the truth. The stereo is really Fabian's. And he did not give permission for Jasmine to enter his home and take it out. So Zeke goes to Fabian's house. The back door is unlocked. So he enters, removes the stereo, and brings the stereo back to Jasmine. When he brings it back, Jasmine says, "You idiot, I lied to you. That's not my stereo, it's really Fabian's." So Zeke takes the stereo back to his apartment, intending to take it back to Fabian. But the next day, he decided he was going to keep the stereo. So what is Jasmine guilty of here? The 4 options are burglary and larceny. B is solicitation and burglary. C is solicitation, conspiracy, burglary, and larceny. Or D, conspiracy and larceny. All right, so a lot of people are saying C. One person said D. It looks like, all right, look like we have a lot of C's. So I'm going to ask someone who typed C. Oh dear, there went chat. to Claire. Claire Lee. Why do you think it's C? You can unmute to talk. Oh. Well, Claire is going to be a little shy. What about Mia? Mia, do you want to unmute and tell us why you think it's C?
I think it's C because, like, if you look at all the definitions of each crime, yes, it's like it fits what they did basically.
All right, well, why does it fit what they did? So you said you looked at the crimes in NRS 200. Why do you think Jasmine is guilty of solicitation?
She's guilty of solicitation because she is trying to obtain something from someone, and she asked Zeke to help her get it from Zeke.
Okay, does someone else, not Mia, want to explain why I think conspiracy is part of the correct answer? Let's see who else picked C. Mackenzie George. Why do you think conspiracy? Why do you think she's guilty of conspiracy?
I think she's guilty of conspiracy because she's working with another person to take something from someone else, even though the other person doesn't know that she's making them do that.
Okay, that's a good explanation. Let's see. Someone said D, which is conspiracy and larceny. Mia Y said D. Do you want to explain why you think it's larceny as well as conspiracy?
Michelle, please unmute yourself.
As soon as they start playing the song and he seen my dad, and
Michelle, can you
he
please unmute yourself?
immediately start crying. And all he told me was like, "Oh," I was like, "What is that? Oh, you know." I'm like, "Oh,
Michelle,
yeah,
can you unmute yourself?
Yeah.
Okay, who else picked C or D? Yeah, Gabriel, go ahead.
Okay, so I picked D because I felt, well, it was the only one that didn't have burglary. And from the definition of burglary, she didn't do that because burglary is basically, word for word, it's a person who by day or night enters any house, room, apartment, etc., with the intent to commit grand or petite larceny, assault or battery on any person or any felony to obtain money or property by false pretenses. She did not do that. She did not break and enter. She didn't go in. She didn't burgle the place. It was Zeke who did that. So she wouldn't be tried for burglary. She is definitely guilty of conspiracy and larceny, but she's not guilty of.
So you picked D.
That's why I
didn't have burglary. Okay.
Yes.
I thought I think I'm just putting down. All right. Felicia, do you want to go over the correct answer?
Sure. Now that I'm on, you can hear me better now, right?
Yeah, we can hear you better.
Okay. The actual answer is actually A, burglary and larceny. And just to pick up on what the young lady was just saying, when this question raises the issue of not committing felonies with friends. So, and that's kind of the cute way of saying when you are part of a crime and you have done something to make that crime happen, you can be found guilty of that crime as if you did it. So let's say, let me go through the reason for this one, and then I'll give you a good example of how you can not be the one to be going into the structure at question, but still be guilty of burglary. So choices B and C are wrong because solicitation kind of goes in or merges with the crime. So once you solicit somebody to do something and then you guys actually pull off that crime, you're no longer solicitation. Solicitation happens when you're trying to get someone to do it and they haven't yet done it. That crime is complete. Okay. So choice D is incorrect because conspiracy requires the agreement between two or more guilty people. So the issue there was that Zeke didn't know he was committing a crime when he committed it, so he couldn't be part of a conspiracy. So that's why that one is wrong. So because the other three are wrong, burglary and larceny are right. But let me give you a quick explanation as to why she would be responsible for burglary, even though she didn't burglar or go into the structure. So as part of a group committing a crime, like say a bank robbery, and you have someone who is just going to be the getaway driver and sits in the car and waits while everyone else goes in, but he leaves the car running so he can zoom off as soon as they're done. That person is guilty of the burglary, of the bank robbery, and of any other assault or batteries that happen inside that bank. So once you commit a crime with a bunch of people, you're guilty of everything. So she's guilty of burglary because she got that person to go. But for her, Fabian's stereo would not have been stolen. So she is guilty of burglary. Does that make sense? Because she put this whole thing in motion. So she has culpability for it, even though she's not the one who did it. Okay. Is there any questions, or are we ready to move on to the second one? Yes, Brian, if you enable the crime to happen, you're guilty. So another good example of this that's kind of more on point is if, so say I wanted to kill, and this is in the news. So say I want to kill my husband or someone else, but I don't want to do it. I want someone who's stronger than me to do it, or someone who doesn't, like a hitman. So if I hire a hitman and tell him, go kill my husband, and the hitman does in fact kill my husband, we are both guilty of murder because that hitman actually did it and I got him to do it. I was, quote, the mastermind. And I put all of that in action. But for my actions, that person would still be alive. That hitman, whoever it was, would not have gone and killed that person. So I'm just as culpable for the crime because I put that in motion. And that was that one. Okay, I'm going to answer your questions in chat. So that one was kind of to teach you about how the crimes kind of slide in and out together. So she's not guilty of solicitation because that crime merges in with the actual theft. So solicitation in this, you will see a little bit here. You can solicit someone to do something illegal and you're guilty of solicitation even if that crime did not happen. So
I think a good example for that would be if I asked Felicia to go steal Patrick's car, to go carjack it. That's illegal. We can't carjack cars. But if she says no, I'm still guilty of soliciting her to try and carjack the car. It's still theft, solicitation. But Felicia is not guilty of anything because she didn't say yes and she didn't go steal Patrick's car.
okay. So let's look at Davis, who's a 17-year-old dropout who lived in Oakland and belonged to a neighborhood gang called the Raiders. One day, Parcells was walking along the street in Oakland. Davis saw Parcells and knew he was a member of the Jets, a rival gang based in Berkeley. Davis accosted Parcells and pushed him to the ground. Davis then pulled out a knife, held it to Parcel's throat, and said, "Who gave you permission to enter our turf?" Before Parcels could respond, Simpson, who was Davis's friend and fellow Raider gang member, approached and asked what was happening. Davis told Simpson that Parcels belonged to the Jets and came to Oakland looking for trouble. Simpson then said to Davis, "Why don't you show him what happens to Jets who come to Oakland looking for trouble?" Davis then stabbed Parcels in the throat, killing him. So Simpson is most likely guilty of which of the four? Do you want to put your answers in the chat?
To answer, I think it was Jana's question before it gets buried. Zeke would be guilty of theft, not theft, burglary and larceny because he did take the stereo, even though he didn't know it was not entering Jasmine's. Jasmine's, yes.
So there's a lot of people that put D in. There's all the answers. So obviously some of you are correct because I see all A, B, C, and D here. But it stopped on a lot of C. So someone who picked D, and I'm just gonna pick Genevieve picked B. So I would like you to explain why you thought it was B, and then I'll pick someone who picked D. Do you want to unmute yourself and say why you thought it was the answer?
Yes. So Simpson's words of encouragement to Davis. So basically Davis is like following Simpson's words. He needs to like be led, and he needs someone to tell him what to do. So if Simpson didn't tell Davis not to stab Parcels, Davis might have not stabbed Parcels, but for Simpson's words of encouragement, he did.
Okay. So what you're saying is correct, but there's a better answer. I want someone who picked D. Zachary, can you unmute yourself and say why you picked D?
I picked D because I thought it was a encouragement. But if he did say his actions would have caused Simpsons to stab him, so it was either the actions would have caused him to stab him. So I thought that was the reason for it.
Okay. So his words did encourage him to stab him, and Parcel stabbed the poor Jets kid if Simpson hadn't yelled. So that is also factually correct. How there's one answer that kind of combines what we're looking at is accomplice liability, and the accomplice has to have the specific intent, what we went over, and the accomplice must aid, abet, or encourage in the commission of the crime. So only choice A addresses both of those elements of the specific intent, because it said he had purpose, and the words of encouragement. So when you're looking at accomplice tests, you don't use the but-for test. That's more of the question we were looking at before. But this one is a little bit different because you're looking at what it takes to be someone's accomplice. So it's a higher level of culpability when you're looking at why. So you guys are on the right track. It's the people who had A were right because they have those two elements. The specific intent is what is missing there. And when we went over in the video, and there's going to be some questions that separate for you specific intent and general intent, but specific intent has to be aimed directly at a purpose, whereas general intent is more of a reckless behavior type of situation where like battery, the intent can be transferred in a general intent crime. We'll get there when we talk about some questions that have to do with general intent. Okay, I don't, wait, let me make sure I don't miss anything.
If you guys have questions on number 2, go ahead and type them in chat. Although if you don't have questions, we're gonna move on to number 3.
Okay. Do you want to do this? Okay.
So number 3 deals with someone who isn't very good at driving. Can we get the specific differences between the choices? Okay, we can talk about 2 a little bit more. That's fine. So the reason that 2, the answer is A and not B, C, or D is because B, C, and D all have the but-for test. So the but-for test says that if not for Simpson's encouragement, Davis would not have killed the Jets guy, Parcells. A doesn't have that. And when you're an accomplice under the Nevada statutes, the but-for test doesn't apply. The only thing that applies in order to be an accomplice and to be liable for being an accomplice, you have to have the specific intent as the accomplice that the crime that you're encouraging be committed, and you have to actually encourage them to do it. So you can have the idea of, like, I want him to stab Parcells, but if you don't say anything, if you don't encourage it, if you don't aid it, then you're not an accomplice, because you don't go to jail for thinking bad thoughts. So because Simpson intended for Davis to stab Parcells, and he said, why don't you show him what happens when you trespass in our neighborhood? It meets both requirements for accomplice liability. The other 3 have the but-for test, but that's not something you look at with accomplices. That's why it's A and not B, C, or D. These questions deal with a lot of statutory interpretation, and that can be difficult, but it's something you get better with over time. So if you struggle, don't feel bad. Does that help? All right. Then we'll move on to number 3. Number 3 says that one afternoon, Ralph is driving his car on Wilshire Boulevard in downtown LA, and he's already late for a business appointment. He's becoming very upset because of the heavy traffic. Suddenly, he decides to drive his car along the sidewalk to avoid the traffic jam. While he's speeding down the sidewalk, pedestrians were scurrying to avoid his car. His car struck Amy and killed her. Which of the following answers is the best theory regarding Ralph, the driver's criminal liability? So you guys are already typing. So I see a lot of B's and I see a lot of D's. I don't see any A's or C's yet. So I'm gonna have someone cover B and someone cover D, and then we will go from there. Christian O, why don't you explain why you think it's B, as in Bravo?
I believe it was B because his intention was to avoid the traffic jam, which kind of transferred into accidentally injuring a person. So while the intent wasn't to kill the person, the actions that they took led to that.
All right, so you're saying his intent to drive on the sidewalk transferred to killing the pedestrian. Okay.
Yes.
Okay. we are going to go to someone who is on D. Grayson. I don't know if I'm saying your name correctly. Gracyn. I don't have a last name.
Yeah, that's right.
Why don't you explain why you thought it was a D?
I thought it was D because it was like Dee says, like it was dangerous to drive like off of the road, and he didn't mean to kill anyone, but he still ended up hurting someone, and he probably knew that like that was not the correct thing to do, but still did it anyway.
Okay. So you're saying he was reckless, and his recklessness is why he's guilty.
Yeah.
Okay. So the correct answer is what Grayson just said. It is D. Commission of an act highly dangerous to life without an intent to kill with disregard to the consequences. The reason it's D and not B, and I'm not going to address A and C because no one said A and C, is because this is what we call general intent. He didn't specifically intend to kill anybody. He didn't specifically intend to, I know robbing a bank isn't on here, but rob a bank. He was reckless. He knew he shouldn't have driven down the sidewalk. And because he was reckless, he had the general intent to drive on the sidewalk. And that's why that is why D is the correct answer. I am all tongue-tied today. To elaborate a little bit, driving on the sidewalk is a dangerous act, right? I think we can all agree on that. And when you do a dangerous act, it's likely to have bad consequences. A reasonable person wouldn't drive on the sidewalk like Ralph did. And because a reasonable person wouldn't do that, it's considered reckless. And it's disregard for human life, which is why it's D.
I didn't see any questions in the chat, so let's move on to number 4, Jimmy and Chrissy playing tennis at the racket club. And after their match, they go to have a couple of drinks in the lounge. And Chrissy said, Jimmy pulls out his tennis racket and says, Chrissy, your backhand is terrible. Let me show you how you should be swinging it. And while swinging his tennis racket at the bar, he begins to swing it carelessly. And while he was swinging his arm in a backhand motion, he accidentally hit Ivan in the mouth with the metal edge of the racket. Ivan, who was standing behind Jimmy while drinking a beer, suffered a deep gash on his lip that required 20 stitches. Which of any of the following crimes could Jimmy, the tennis player, be found guilty? So there's 3 choices, or no, he didn't because he hit him accidentally. So what does everyone think that he's guilty of?
We have a lot of answers, a lot of different ones.
Yeah, we do have all of the different ones on here. I see one from all A, B, C, and D. Oh, goodness. Okay. So I'm going to say, let's have someone explain an A answer and a B answer, because I think I saw the most of those at the beginning. So let's say, Catherine, Brian, can you explain your A answer?
Sure. So the definition, the legal definition of battery is in criminal law, this is a physical act that results in harmful or offensive contact without that person's consent. So, but it has to be intentional. Mayhem is when you disable a person, which he didn't disable Ivan. And assault attempts to cause or purposely knowing or recklessly causing bodily injury to another. So he recklessly caused bodily injury to another. So that's why I chose assault.
Okay. And let's see, can someone, I'm curious about these no crime answers. Caden, can you unmute and say what you see?
Yeah, I don't think he's guilty of anything because intent isn't there. And unless they're looking at strict liability, that's required for everything else.
Okay. So you both, the key thing in both of your answers was you were looking at intent, which is a factor of this question. So you're on the right track. The right answer is battery. It's B because it is unlawful application of force to the person of another. So we have the bodily injury, that part is there. So that's why it's not assault, because he actually made contact with the person. But let's talk about the intent, because both of you felt that in your own way why the intent was missing, therefore it wasn't a battery. So battery is a general intent crime. Remember we were talking about this specific intent to hurt that kid in the Raiders territory. This is the opposite. This is the general intent. It means you don't have to intend to commit the specific crime. Rather, it's used to encompass all forms of the mens rea requirement. Remember we talked about the guilty mind being defined as mens rea. You may be guilty of battery when you act recklessly, negligently, or with knowledge that your act or omission will result in criminal liability. So in this case, it's a criminal battery because he recklessly swung his tennis racket in a crowded lounge area. So even though he didn't specifically mean to hit Ivan, his conduct was an unreasonable risk of harm to others. So that's when your intent, it doesn't have to be I need to specifically hit you. Sometimes when we talked about transferred intent before, sometimes when you swing at one person and you actually hit another, the intent will transfer because battery is a general intent crime. When we talked about how those are the crimes where you don't actually need, he didn't actually need to say, I'm going to hit Ivan in the mouth with this tennis racket. But because he's swinging and there's tons of people there, it's like the driver before, he's got a general intent to do harm because he's doing something very, very reckless. Does that make sense why it's different from specific to general? It's because of the type of crime it is. I don't see anything. Oh, one new message, let me see. So that one makes sense. So do you want to move on to the next one?
Number 5. All right, this is the same set of facts as the question before. So the tennis club and the tennis racket with Jimmy. Assume for the purposes of this question only that before Jimmy began to swing his racket at the bar, he had drunk 3 vodka martinis and was inebriated or drunk. If Jimmy is prosecuted for hitting Ivan, he should be found, and then go ahead and type what you think the answer is in chat. Okay, I see a lot of B's. I saw a couple A's earlier and one C, but looks like it's predominantly B. So we'll have someone explain B. Jonah, do you want to explain B?
So I picked B. He was being reckless and he should have known better even if he was intoxicated.
Okay. Okay, I see what you're saying. So even though he was drunk, he should have not been reckless in swinging his racket.
Yeah.
Okay. You are on the right track. So intoxication or being drunk or being drugged can be a defense to a crime if it negates an if it negates an element of that crime. So like stealing. Stealing is a specific intent crime. So if you are too drunk to have the intent to steal, you can't be guilty of stealing. But battery, like Felicia was saying earlier, is not a specific intent crime. It's a general intent crime. So simply being drunk cannot negate the intent required to commit battery. So he's drunk. He still had the intent to swing his racket. It's still battery. And what Caden is saying is correct. So if someone spikes your drink, or if someone gives you, let's say, a brownie and you didn't know it was like a marijuana brownie, let's say. If you didn't have the intent to get drunk and you didn't know like that your drink was spiked or that the brownie had drugs in it, then there could be an argument that, well, they didn't have the intent to get intoxicated. They didn't know. So that could negate the general intent here. But he knew he was getting drunk. So the correct answer is B. Yes, bravo.
Okay, I'm not seeing a lot of questions here. So you're right. Yeah, okay, she just answered you. Okay, so let's go on to number 6. And Olga Oslo, who is an executive vice president in the investment banking department of the National Bank. And she's having lunch with her boss, Amy. And Amy excused herself to go to the bathroom. As Amy stood up to the table, her wallet fell out of her purse onto the floor. She was unaware of what occurred and proceeded to the bathroom. Olga, however, saw the wallet fall. Intending to steal it, she picks it up and puts it in her pocket. Before Amy returned to the table, she had a change of heart and decided to give the wallet back. Olga told Amy what happened and handed her the wallet when she returned from the bathroom. Which, if any, crime is she guilty of? Okay, I see mostly A, B's. So we'll have someone explain each of those. Let's see. How about Hannah Porter? Do you want to explain why you picked A?
Yeah, so I picked A because even though she thought about it and she really she was like, okay, and she literally put the wallet in her pocket, she didn't actually steal it. Like, I mean, technically she did, but she did give it back. It would have been a different story if like someone caught her on camera and then they like reported her, but she ended up giving it back. So that's why I chose A. I thought it was no crime because she didn't get caught with it.
You didn't get caught? Okay. How about Mira Banker? Can you tell me why you picked B?
Yeah, I picked B because I think I'm pretty sure that even if like you have the intent to steal something, even if you don't leave the premises, I think it still counts as like larceny. And it didn't say grand or petite because I don't know how much was in the wallet, but I think it still counts even though she didn't like go through with it because she intended to steal it and like put it in her pocket, which was like stealing it in and of itself. So
okay. So in this situation, larceny happens a lot in our cases. The correct answer is B. So let me change the facts up a little bit and see if you can see where the reason that she's guilty. So say you're in a store and you decide to steal some Skittles and you put the Skittles in your purse and you walk to the edge of the store, but then the security stops you and says, hey, I know you have Skittles in your purse, and you say, oh, I'm sorry, I'll just give it back to you. Would that change your answer? Is it what she said earlier, that because she didn't get caught by someone else, it doesn't make it a crime? Okay, I'm curious why it would say it would change your answer. So Marie, can you tell me why you think it would change your answer? She still didn't leave with the item.
Because I guess that makes larceny more about the intent, even if it was reversed. I don't think the intent can actually be reversed. So in that moment, because they intended, like in this example, they intended to steal it, they were just stopped midway. I guess that still makes it larceny because it doesn't matter how they were stopped. It more matters how they tried to do the crime or whether or not they tried to do the crime.
Right, the intent matters here. So what I'm getting at is that the answer is B, larceny, because she did the slight movement of taking away the property. Remember, she put it into her own pocket. At that point, her crime was complete. She intended to steal it. She concealed it by putting it into her pocket. So she moved it away. So she took it away from Amy with the intent to steal it. So then with the intent to deprive her thereof. So just because you have a change of heart and you give it back, it doesn't mean that you didn't. She completed her crime. She did steal it. She did have the intent. And so changing your mind after doesn't negate the crime that already occurred. So to answer Kaylin's question, how would Amy charge her if larceny, if she didn't know anything was stolen? So that's kind of like a crime that nobody sees, but then you realize it happened afterwards. So Amy would realize at some point that her wallet was missing and report it. So she admitted she stole it, but she just decided to give it back. So deciding to give it back after you committed the crime doesn't mean you didn't steal it. It all just happened. It's really putting that intent into focus because it's all happening at the same place. So, and yes, in these facts, Samuel, it would be up to Amy if she decided she was charged because she did commit the crime. But unless someone at another table saw her and will speak up, it would be up to Amy under these facts. Does that make sense? Once the crime is done, the crime is done. And what it's looking at is your intent at the time. So Olivia's asking, would there be a situation where they would be guilty if they stole something? So once you steal something, you're guilty of stealing something. So when you say they stole something, then that is all of the elements are there and you've done it. So it's over. Whether or not you get caught is not actually an element of the crime. So getting caught doesn't play into it. And that's what they're trying to show you here. Of course, everyone that you would deal with in the trial by peers program did eventually get caught. So you wouldn't have those, but it's just to focus you on the intent here.
So we're going to move on to the next question, number 7. It's about Armando and Angelina. Armando lives with his girlfriend, Angelina. They're not married, but they live together in a house that's owned by Angelina. They've been there for 5 years. One day, Armando got angry at Angelina after learning she was having an affair with another man. To get back at Angelina, Armando decided he would set fire to her house. Late at night, using an electronic device, he opened up the garage door and entered the structure. The garage was attached to the basement of Angelina's home. Armando carried in a 5-gallon gasoline can and spilled the gasoline around the interior of the garage. Hearing suspicious noises, Angelina came into the garage. Before Armando could ignite the gasoline, he was stopped by Angelina, who then called the police. Armando was arrested and charged with burglary. He should be found what? Go ahead and type your answers in the chat. All right. So there's a lot of B's and a lot of C's, which means you either think he's guilty or he's not guilty. So those are very different answers. We're gonna have someone talk about option B first and then option C. Jaden P, why don't you tell me why you think it's B?
I think he's guilty of committing arson or planning to, but I don't think he's guilty of breaking in because he did live there with his girlfriend. And as of now, there was no evidence that he was kicked out or moved out yet. So he didn't technically break in or enter, but he did plan to commit arson, which is a crime.
Okay. Thank you for that. I'm going to elaborate at that after someone tells me why they think it's C. Let's see. I don't think Grant Kobe has talked yet. So Grant, why don't you tell me why you think it's C?
So I said C because as far as I'm concerned, there was no breaking into the dwelling of another person because they technically already lived together. So that was just my thought process behind it.
Okay. All right. So now that we've heard B and C, the correct answer is C. And Grant is 100% right. It's not the dwelling of another. He may not own the house, but he definitely lives there. It's just like an apartment. You don't own an apartment, but it's definitely your dwelling. Jaden was technically right. He did plan to commit arson, but the question isn't asking about arson. It's asking if he should be found guilty or not guilty of burglary. And he cannot be found guilty of burglary because he did not break into the dwelling of another. And that is one factor that is required for someone to be found guilty of burglary. So I don't see any questions on that. So we are going to go on to question 8, which is the same set of facts. Is Armando guilty of anything? Why or why not? And I'm going to use Jaden's answer again because she's right. He is guilty of arson. Attempted arson because he didn't actually set anything on fire, which is a requirement of arson. So Armando is guilty of attempted arson. He made a specific act, a specific overt act towards committing arson by spilling the gasoline. Therefore, it is attempted arson. Would it be malicious intent? I mean, he did have the intent to be malicious, but here we're looking at specific versus general, and arson is, I believe arson is a specific intent crime, and Felicia can correct me if I'm wrong there. Okay. So he specifically intended to commit arson. He didn't, but there was an attempt. So attempted arson.
Okay, so let's do number 9. Inka and Eli have been dating for over a year. One day, Inka was walking in the Golden Gate Park when she noted Eli sitting next to a woman on a park bench. She observed him kissing the woman, passionately embracing her. Despondent by her boyfriend's public display of infidelity, she aimlessly began wandering around the vicinity of the park. She passed by the tavern. She decided to go in and have a drink. After guzzling down a couple of beers, she started having a conversation with Raven, a customer seated next to her. They began commiserating about their relationships with unfaithful boyfriends. And while they're talking, they continue to drink the beer with an occasional shot of tequila. So they soon become intoxicated. As they discuss ways to get back at Eli, Raven suggested they set fire to his house. With Inga in agreement, the two women staggered from the bar and went to Eli's home. Under the cover of night, they picked up little twigs and tree branches and stacked them alongside the outside of Eli's home. Inga then lit them with her cigarette lighter. As the branches grew into flames, they hurried away and ran away. Seeing smoke from his bedroom window, he ran outside and immediately extinguished the fire with the garden hose. The fire slightly charred a small section of the exterior of his house, but did not cause any significant damage. If she's prosecuted for larceny, what should she be found guilty of, if anything? Okay, so I'm getting a lot of B's, a lot of B's. Okay, let me see. Who hasn't talked yet? Oh my God, did everyone say B? Kaylin, do you want to explain why you said A? Oh, I'm getting some C's now. Kaylin, do you want to unmute?
Yeah, so earlier in the initially my answer was B, but we had the question earlier which said that intoxication negated her defense, the intent, so I changed my answer to A.
Does someone want to explain a B answer? How about Gabrielle?
Okay. I said B because she chose to go into the bar, or they called it a tavern? Yeah, a tavern, and she chose to consume the alcohol, and she as an adult, I'm sure she knew that intoxication is what happens when you drink alcohol, and so then what, she didn't do anything to stop like Raven from like Raven suggested it, but Inca still lighted the fires. She's definitely guilty of arson.
Okay. Arson is defined as the malicious burning of the dwelling of another. By definition, arson is a general intent crime because it does not require specific mental state. As a general rule, voluntary intoxication is no defense for the general crime. So remember when we talked about, when Lexi was talking about intoxication, negating a specific part of it, and how if it's a general neglect crime, intoxication will not negate it. So it's no defense here. So the answer is C, they're guilty because voluntary intoxication is no defense, and she knew she was setting fire to the dwelling of another. So that's back to that general versus specific crime.
Also, I will add, I made a mistake earlier. I said arson was a specific intent crime. That was not true. So this is proof that even attorneys make mistakes sometimes.
Hey, everybody does. So that one's just back to our intent question. So if we want to move on.
I will take number 10. So number 10 says, Mona Lisa was employed as a sales clerk at Huffington's. She worked in the women's department store, or the women's clothing section. Mona Lisa usually worked weekdays from 10 a.m. to 6 p.m. One evening around closing time, Reba, Mona Lisa's girlfriend, came to see her at Huffington's. Reba and Mona Lisa had planned on going out to dinner after work. When Reba arrived at Huffington's, she placed a shopping bag on the counter and went to the restroom. Earlier in the day, Mona Lisa had taken a diamond necklace from the jewelry section of the department store and wrapped it in tissue paper. Mona Lisa then stuffed the necklace in Reba's shopping bag, intending to remove it after they left the store. Moments later, Mr. Huffington, the store owner, approached Mona Lisa and told her she needed to stay late in order to do inventory. So when Reba returned from the bathroom, Mona Lisa told her she could not accompany her, but would call later. After leaving Huffington's, Reba went home. Upon opening her shopping bag, she was surprised to see the tissue paper with the store emblem. And then she opened the diamond necklace. Believing the necklace had accidentally fallen into her bag while she was at Huffington's, Reba planned to return it the next day. However, the following day, she changed her mind and Reba sold the necklace to a friend for $1,000. What is Mona Lisa guilty of? All right, it looks like we have a good mix between D, A, and B. Seems like a lot of you picked B. So we're gonna have someone talk about why they picked D and then B. So D first. Christina, I don't think you've spoken yet. So why don't you tell me why you think it's embezzlement? Maybe. All right. Christina doesn't want to go. What about Sarah L? Why do you think it's embezzlement?
I think it's embezzlement because she was at work, so she took something that belonged to the place she worked at, and I believe that's the definition of embezzlement. So that's why I thought it was.
And then we need someone to tell me why I thought it was B, larceny. So Kenzie is already gone. Let's see here. Emma, why don't you tell me why you thought it was B?
I thought it was larceny, just that she had the intent of stealing it, and then the moment she kind of took it from the case, she already committed the act of larceny. I ruled out A because it happened, and then I think obtaining property or embezzlement would fit this instance.
All right. So the correct answer is bravo, B, larceny. So it is larceny because Mona Lisa is a sales clerk, so she only has custody of her employer's property. She doesn't have ownership of it. So because she's only a sales clerk, she doesn't have lawful possession of the necklace. Therefore, she's guilty of larceny for the theft. A is wrong because it's not an attempt to commit larceny. She did actually commit larceny. C is wrong. Well, you guys didn't pick C. C doesn't matter. D is wrong because she is not been entrusted with the property. And that is a key element of embezzlement. So because she was not entrusted with it, and because she actually completed the larceny, the correct answer is B. Is larceny a specific intent crime? Yes, it is. You have to have the intention to steal.
Remember when we talked about Olga putting the wallet in her purse? She had that specific intent to take this and deprive Amy of her purse. That's what makes it specific. I specifically intend to take this object and keep it forever and deprive the rightful owner of it. So even if I change my mind later and forever doesn't become as long as it could be, it's still a specific intent to take that item. So I don't, oh, you guys are answering each other's questions. Oh, cool. So the idea being embezzlement is what you think of when you think of those white collar people who have like investments. So they have rightful ownership of or rightful possession of your of your money.
Like a
And
financial advisor.
right. Or like people on Wall Street, right? And they'll invest your money for you. They have the right to sell things on your behalf, sell your stuff, get new stuff. So they have rightful ownership of your money. And so when they take it from you, that's embezzlement. Think of it that way. Like who has the right? So it's not just that she wasn't working in the jewelry department because she just had mere possession of it. It's not like she could have told her boss, okay, I have this necklace. I'm going to take it home and wear it to a function and bring it back tomorrow. That wouldn't have been okay. Does that make sense? Just because you're not in that right department, it's not, it's her level of employment. Lower level sales clerks in every department don't actually, they just have custody of items. They don't actually have the lawful possession. Okay. Let's go to number 11. What is Reba guilty of? I'm seeing a lot of C.
A lot of C.
Oh, there's an A. Okay. I want someone who said C to explain. Let's see. How about, and I know I'm going to say this wrong, Tayani?
Yanni, or it could just be Yanni. It's okay. I think it was C because she received the stolen property, and even though she knew it wasn't hers, and she saw that it wasn't hers, but she still stole it, or kept it, and then sold it, which would be Russian.
Okay. Because she kept it. So let's see. Coco, do you want to say why you picked A?
I picked A because she did receive what Mona stole. That's pretty much it. I didn't think it was larceny because she didn't steal it herself. She just received it, and she didn't know it was stolen. So I guess that's my answer.
Okay, well, you're on the right track because Reba did not know the property was stolen when she first found it. So she's not guilty of receiving stolen property because she must know that the property is stolen at the time when it becomes her possession. So it was Mona Lisa and not Reba who took the necklace out of the possession of the store owner. So when a person takes possession of property with an innocent intention, he or she does not commit the trespass, so he cannot be guilty of the larceny, even if they later succumb to the temptation of keeping the property for him or herself. So she didn't have the intent at the time, and that's what this question is asking you about. So this is like the inverse of the stolen wallet. There's zero intent here, and then later her mind is changed. So it's D, neither receiving stolen property nor larceny. She's not guilty of anything because she didn't do it. Her girlfriend, Mona Lisa, is still guilty though. Okay. I'm not seeing any questions. Are we ready to move on to number 12?
So what would she do? Oh, God, please.
She's not guilty of anything. Her girlfriend's guilty. And that was the question of the question before. So someone would be guilty of stolen property under our laws if you knew or reasonably should have known. So if your girlfriend gives you a necklace, that's not a reasonable automatic knowledge that it would be stolen, right? You could be for a gift or something. But say you got your friend lends you a car and there's a screwdriver in the ignition and he said, oh yeah, I lost my keys, just jangle the screwdriver and it'll start. That should give you a reasonable suspicion that that car is stolen. So you would be receiving stolen property when you took the car. So you have to have something there that would give a reasonable person knowledge that it was stolen. So either you knew it or you reasonably should have known. It's like the cars incident. And to answer your question, Coco, the one who stole would still be guilty, but not the one who received it. Because remember, she wasn't guilty of anything. So if she gives it back, then she's just giving it back. That's like finding it and then finding the stolen one, returning it to the person. The third party is not guilty.
All right, we're gonna move on to number 12.
You want to do the next one?
Yeah. Number 12 says Keith Kenworth drove to Madison Square Garden to go see the dog show. Keith parked his car on the street 2 blocks from Madison Square Garden. While he was inside the arena watching the show, Grayson stole the car and drove it to Coney Island. Grayson planned to take the car to a deserted warehouse and strip the vehicle. While he was driving Keith's car, the brakes suddenly failed and the car veered out of control. The car jumped the sidewalk and crashed into a home owned by Eva, causing extensive damage to the dwelling. Grayson was arrested and charged with larceny and the separate crime of malicious destruction of property. At trial, the prosecution and the defense both agreed that the malfunctioning of the car's brakes caused it to veer out of control and damage Eva's home. Assume that Grayson is convicted of larceny for the theft of Keith's car. With respect to the second charge of malicious destruction of property, how should he be found? A lot of A's, some D's, some C's, a lot of A's. Okay, we're gonna have someone talk to us about A. I don't think Isaiah has gone yet. So Isaiah, why don't you tell me why you think it's A?
Okay, can y'all hear me?
Yeah.
All right, so the reasoning for me like choosing A was
It's kind of boring, but yeah, we're just going to.
huh?
Isaiah.
Oh,
Kenzie, can you go on mute? Oh, there you are. Go ahead.
yeah, I chose A because I thought that like in order for it to be malicious, it would have to be on purpose because that's kind of like, you know, in the definition of malicious. So I feel like since the accident resulted from the brakes malfunctioning, that it's evident that he didn't crash intentionally. So that's why I put A for my answer.
Okay, that is basically on point entirely. A is the correct answer. B, Bravo, is not the correct answer because larceny and malicious destruction of property are 2 separate crimes. C is not the correct answer because that intent does not transfer. D is not the correct answer because general intent crimes still require a mens rea or an intent requirement. We can sub that with recklessness. That's why earlier driving on the sidewalk was considered a crime when he killed somebody. But here, there was no intent to destroy the property. He did not maliciously run the car into the house, like Isaiah said. It was because the brakes malfunctioned, so there was no intent. So A is the correct answer.
Okay. I don't see any questions in the chat, so we'll go on to number 13 with Mallory and Tinker. Oh, then I say that and then they pop up. The answer to number 12 was A. Oh, Lexi did it. Okay.
Oh,
So let's
Katya
go on
has
to
her
number
hand
13.
raised. Oh, hang on.
Oh, go ahead.
Katya, why do you have your hand raised?
If I just want to take attendance. So when you get a chance, just send me an email with a fun fact about yourself and your full name, and that'll count as attendance for today.
Okay. Let's do number 13. So Mallory and Tinker agreed to burglarize Rosario's home, While they were planning out the burglary, Mallory informed Tinker that Rosario's home had a sophisticated alarm system that needed to be disarmed. Tinker told Mallory that he knew Blick, an alarm specialist, who could help disarm the system. Tinker then approached Blick and asked if he would assist them in disarming Rosario's alarm system. Blick said that he did not want to participate in the crime, how to do it himself. So Mallory and Tinker thereafter went to Rosario's home to commit the burglary. When they arrived, they saw a vicious guard dog patrolling the fenced-in area. Deciding it would be too risky to confront the dog, they abandoned their planned burglary. Which of the following is the most accurate statement regarding the criminal liability of Tinker, Mallory, and Blick? So A, B, C, or D? Okay, so a lot of B's and then some C and D's come in. Let's see. I'm trying to pick someone who hasn't gone yet. That picked C. So let me see. I think Isaiah already talked. So
I don't think Ariana has talked.
thank you. Ariana, do you want to explain your answer?
Sure. So I picked C because the first two people was like have conspiracy of robbing someone's house, but it didn't go through with the plan because of the dog. And Blink was guilty of attempt burglary because he told him how to do something, like help them get information to rob the house.
Okay. And then let's see, someone who picked, how about Tyler? Can you tell me why you picked B?
I picked B because all three of them agreed to either actually try to attempt stealing something or helped. So all of them were, I don't know, is conspiracizing a word? I don't think so. But they all agreed to help in some way, even if it wasn't actually completed.
And you are actually, that's right. That's the difference between B and C, is that you were dead on. Blick knew of the conspiracy and intentionally helped the objective of breaking into the house, even though he didn't enter into the agreement himself. That you've heard of that aiding and abetting. That's exactly what happened. He helped, but for, and I don't want to use the but for test, but because he helped teach them how to disarm that, he's part of the, and he knew that they were doing it to break into Rosario's home. He's part of that conspiracy. Your answer is absolutely correct. And you explained it well. So do you want to move on?
I think it's important to talk about why it's not attempted burglary.
Oh, okay.
So the reason it's not attempted burglary is because the three of them did not commit a substantial step in the burglary. Driving to someone's house is not a substantial step. If they had broken down the door and then changed their minds, that would be a substantial step. It's similar to the arson question from earlier. When the guy poured the gasoline, that was a substantial step in committing arson. Here, the group didn't take that step simply by driving to the house. There's nothing wrong with driving to someone's house. So it's not attempted burglary. It is only conspiracy. We're going to go on to 14 then. Smelson was employed by the B&O Railroad Company as a watchman at its crossing to give warning to the public of approaching trains. Late one evening, he fell asleep in his shanty and failed to warn of the approach of an upcoming train. Fishbone, who was driving his car, knew of the usual presence of the watchman. As he approached the crossing, he received no warning. Driving onto the track, Fishbone's car was struck and crushed by the train. Fishbone died instantly. A few minutes after the accident, Police Officer Rose arrived at the crossing and walked into the shanty. As he entered, Smelson then awoke. Rose asked him what happened here, and Smelson made incriminating statements. Smelson is subsequently charged with involuntary manslaughter. His motion to prevent the introduction of his incriminating statements into evidence will be granted or denied, A, B, C, or D. I think we have a mix of A's and C's. I see a lot more A's than C's. So Samuel S., I don't think you've given your feedback yet. So why don't you tell me why you think it's A?
I think it's A because the officer did not give him his Miranda warnings. And it wouldn't be B because he wasn't trying to interrogate Smelson. He was just trying to understand what happened. But since he did not have his Miranda rights told to him, he was not able to have anything that he said be held as evidence.
Okay, I'm off mute. All right. We're gonna have someone talk about why they think it's C, but I'm gonna try and find someone who hasn't talked yet. Brian Wu, I don't think you've given us an answer yet. So why don't you tell us why you think it's C?
Okay, so I think it's C because in C it does state that it took place, the exchange took place in a non-custodial setting, and the question was investigatory in nature. So I think it makes sense because, as everyone else said, Smelson was not read his Miranda rights, and he was asked what happened here, which was like a question into like, how are you involved in this situation and what happened in the situation? So I believe it would be denied.
Okay. So you are on the right track. The correct answer is C. His motion to prevent the statements from coming into evidence would be denied. Miranda only applies when the state or the police here are doing a custodial interrogation. So there's two different facets to that. The first is custody. So that means that if a person is not free to leave, they will be considered in custody. They don't have to be in jail. They don't have to be in a police station. If they do not feel free to leave, it will be considered in custody for Miranda purposes. Here, Smelson is not in custody. There's nothing that indicates that the police officer blocked him from leaving his little shanty. He's just at work regularly. D, I'm sorry, not D, is not an interrogation because the police officer is just trying to get a handle on what happened. Asking for general information is not considered an interrogation under Miranda. Smelson just made those statements on his own. He was not in a custodial interrogation. So the police officer was not required to give Smelson his Miranda rights. So the correct answer is C. Oh, that's not the correct name. To answer Caleb's question, being detained, I'm assuming you mean like in a police station or like in a police car, that would be considered in custody, yes. Okay.
Okay. I don't see any other questions on that one, so we can go on to 15. And the facts are kind of long on this one. So Leach lived at 789 Mesa Drive in Tucson. The police received reliable information that Leach had a stolen Yamaha stereo in his possession. The detectives then submitted an affidavit to a neutral judge setting forth sufficient underlying circumstances for his issue of a search warrant. Making a determination of probable cause, the neutral judge called a magistrate, issued a warrant for the Yamaha stereo at the, quote, premises of 789 Mesa Drive, end quote. The police arrived at his house, showed him the warrant, and came inside. In the living room, they noticed a Sanyo stereo, which had the serial number removed. Upon further inspection, the police determined the Sanyo stereo had been stolen from a local store during a recent burglary. The police then placed Leach under arrest and instructed him to remain seated in the living room while they searched the rest of the house. One of the officers proceeded to the basement where she found the stolen Yamaha stereo. She then decided to search upstairs and came up with a stolen Monoron stereo in Leach's second floor bedroom. Leach is subsequently prosecuted for receiving stolen property. At trial, he moves to prevent the introduction of the stereos, all three, into evidence. Which stereos should be granted to be prevented introduction? So which ones do you think should not come in? Is it A, the Sanyo stereo, the Marant stereo, or C, the Marant stereo or the Sanyo, or none of them? Let them all in. Okay, I'm seeing a lot of C's. A lot of C's, and then I saw a couple D's. So I'm curious, let's see. Camelia, can you tell us why you picked D like Delta?
So initially I thought that none of the stereos should be prevented from being used as evidence because eventually all of the stereos would have been found out to be stolen. And so I guess it would only add on to the charge or add on to the Yamaha stereo being stolen.
Okay. How about Stella? Can you tell us why you picked C?
Yeah, I picked C because the officers only received a warrant for one stereo, which was the Yamaha stereo, not the other two stereos that they found while doing the search and seizure.
Okay. So the correct answer is C, because here the warrant covered a seizure of a stolen Yamaha stereo at 789 Mesa Drive. When the police arrived at the defendant's home, they noticed the Sanyo stereo in the living room. The first question is whether the police would have found it under the plain view doctrine. So if you kind of walk up and see something in plain view, you wouldn't need a warrant for it. So plain view is legitimately only where there's immediately apparent to the police that they have evidence before them. So that's like if you see drugs sitting on the counter, like it's obvious what it is and it's immediately apparent. So on this question, they had, upon further inspection, determined it was stolen, remember? So that means that it was not in plain view. For that is the Sanyo stereo. By the same token, they did not have the authority to keep searching his home after discovering the Yamaha stereo. Remember, it was the Yamaha at 789 Mesa Drive. So when the purpose of the warrant has been carried out, the authority to search is over. So that's why C is the correct answer, because as Stella said, the Yamaha was the stereo listed on the warrant, and they had the Yamaha when they found the Manzaran stereo, and the Sanyo stereo they had to do further inspection, so it was not in plain view. So they had to have gotten a warrant about that one. Okay, someone had a question. What was question for? So I don't see, does anyone have any questions about that one, about how the warrant is detailed? Oh, I don't see any.
Okay, cool. We will move on to 16. Wayne Wilson was arrested in Kansas City Municipal Airport when the small satchel he was carrying was found to have cocaine. Wilson, who didn't challenge the legality of the airport search, was subsequently prosecuted for possession of cocaine. At trial, Wilson testified on his own behalf and said that the satchel belonged to his girlfriend, Jerry Martin, who was accompanying Wilson when he was arrested. Martin died in a skydiving accident 2 weeks before Wilson's trial. Moreover, Wilson testified that although he was a former cocaine addict, he had not used drugs in the past 3 years. On cross-exam, the prosecuting attorney asked Wilson to roll up the sleeves of his shirt and exhibit his arm to see if there were any needle marks. Will the request be allowed or disallowed, and why? A, B, C, D. I see a lot of D, some A's, some C's, but it looks like mostly D. Let's find someone to talk about D who hasn't talked yet. Catherine Bryan, I don't think you've had a chance to speak yet. Why don't you tell us why you thought it was a D?
I actually did speak, but I'll still answer if you want.
Okay, yeah, go ahead. Sorry.
I think it's D because he said himself that he hasn't been a cocaine addict in 3 years. So even though he has a right against self-incrimination, he won't be self-incriminating if his statement is true. So the evidence is relevant to his credibility. So I think that the request should be allowed.
Okay. D is the correct answer because it does go to Wilson's credibility. So after a statement has been admitted into evidence, it may impact the declarants. So the person talking, let's say Wilson here, it may impact Wilson's credibility. It may attack it. And if Wilson's credibility is attacked, we can admit any evidence that would be admissible if Wilson has testified. Wilson has testified. He testified about his drug use or lack thereof. So the prosecution can attack his credibility because Wilson opened the door to it. And so the prosecution can ask him to roll up his sleeves to show if there are any needle marks, because that goes directly to his statement that he hasn't used drugs in the last 3 years. Kaylee, he can refuse to do it. However, because it is a criminal trial, no, I'm sorry, he can refuse to do it because he opened the door to it already, the judge or the jury could make a negative inference. And that means that they would just assume that there are needle marks on his arms. Now, on the other side, if Wilson had just testified that it was his girlfriend's drugs and it wasn't his, and he hadn't said that, he did do cocaine, that he has in 3 years, then the prosecution would not be able to ask Wilson to roll up his shirt sleeves for the needle marks. Isaiah, he opened the door when he testified on his own that he hadn't used drugs in the past 3 years. That's how he opened the door. Okay.
So this one kind of highlights like when you're going to trial and you have a client who is a defendant and they kind of want to testify and tell their side of the story. You got to be really careful because when you have the right not to testify and not to say anything self-incriminating, but when you decide to testify and you say stuff, you are opening the door to cross-examination and for your credibility to be challenged, because every witness's credibility can be challenged by the other side. So you got to be really careful when deciding whether or not you want your client to be testifying. And let me see. So Max Julian, I'm thinking that they're looking for fresh marks. So there would be a difference between old marks and new marks. And then Caden, he could plead the fifth. But when you plead the fifth, it's to avoid saying something self-incriminating. So there is a negative impact. That's like, say, I asked you, did you pick up that pencil? If there was no criminal repercussions, then you would have to answer yes or no. But if there could be criminal repercussions, then you get to plead the fifth. So the other side of that means that as soon as you plead the fifth, everyone in that room knows that there's possible that you're avoiding saying something against self-incrimination. So you are not confirming nor denying, but it does have a negative impact because then everyone assumes that you're not saying it because you don't want to incriminate yourself. Oh, Lexi answered you. Okay, that's true too.
All good. It's different answers, so it's good. Different kinds of answers. All right. I did 16, I think, so you can do 17.
Okay. The Bridgeport police filed a complaint charging Bruce Gray with the sale of narcotic drugs in violation of a state statute, obtained a valid search warrant for his arrest. 2 police officers went to Gray's house, a 2-story colonial located at 2501 Bancroft Drive. After knocking at the door, they were let in by a man who identified himself as Lloyd Gray. One of the policemen, Officer Brown, showed the man the arrest warrant and asked if he was Bruce Gray. He replied he was Lloyd, Bruce's brother, and that he was staying at Bruce's house while Bruce was away on a business trip. The officer then asked the man for some identification. He was only able to produce an out-of-state driver's license in the name of Lloyd Gray. The other policeman, Officer Sawyer, then became suspicious and proceeded to frisk Lloyd. During the pat-down, Officer Sawyer found a letter which read, "Dear Lloyd, if you can get rid of Bruce permanently, we could be together forever. With love, Jennifer." Nervously, Lloyd then agreed to allow the police to search the house. The officers conducted an extensive 2-hour search and found nothing of interest to them. As they were leaving, Officer Sawyer walked over to a parked car in the driveway of the house and noticed the car's trunk was slightly open. When he looked in the trunk, Officer Sawyer discovered the body of Bruce Gray. If Lloyd Gray's attorney files a motion to prevent the introduction of the letter into evidence, the court should deny or grant the motion, A, B, C, or D. Okay, I'm getting B, C, and D. No A's. So let's try from a C. Olivia, do you want to unmute and say why you picked C?
Sure. I picked C because it says that the officer just started searching Lloyd. He started searching him and he didn't ask him if he could. So it was a non-consensual search. So yeah.
Okay. Let me see. Genevieve, do you want to unmute and say why you picked B like Bravo?
I picked B because, as B says, it was obtained pursuant to a valid search. So,
Why did you think it was valid?
because, well, pursuant means in accordance with a law or legal document or a resolution, or following, going in pursuit. So, it was obtained following to a valid search.
Okay. Okay. Mia Yanez, do you want to say why you picked D like Delta? Or is it Maya? I'm sorry. Okay, I guess not. So let me see, someone else who picked D. How about, I know you spoke before, but how about Tyler again?
Yeah, of course. So I was just rereading it right now, and I think mostly the biggest thing for me is why I picked D is that when they knocked on the door, they showed him an arrest warrant, but not a search warrant. And I believe he did let him in, but he didn't actually say they could. He let them in, but he didn't say necessarily you could search, you can do this. So I'm pretty sure that it was illegal for them to do an extensive 2-hour search like they did, and then bring what they found in the search to a trial.
Okay. Okay, so the key in this question, the correct answer is D, is in Delta. And the key in this question, they did have a search, they did have permission to search the house. But remember, the letter was found before he gave that consent. So that makes a difference because D is now the fruit of an illegal search. The Fourth Amendment prohibition against unreasonable search and seizure would be invoked because they didn't have probable cause to search him personally, nor had a valid search warrant. So it wasn't the search of the house that we're talking about, it's the search of the person. So the police must have an objective basis for believing the person was about to engage or already had engaged in criminal activity. So they didn't have that here. Choices A and B are incorrect because they didn't have that. He was just standing there inside the house. He had showed them ID. They didn't have any objective basis to believe he was involved in criminal activity. C, though correct, is the less preferred choice because the basis for excluding the letter from evidence is that it's the fruit or product of an illegal search rather than the result of a non-consensual search. So the answer to Isaiah's question is that just because you're in the home of a criminal doesn't mean that you would be engaging in criminal activity yourself. So that in and of itself is not enough to search him. So no.
Okay, we're gonna move on to 18. 18's kind of long. Smirk was standing on the street corner at South and Broad when police officer Eckert approached him. Officer Eckert gently grabbed his arm and said, "Hey, I want to talk to you." Smirk responded, "About what? I'm in a hurry to go home and watch the Phillies game on TV." Officer Eckert then remarked, "Listen, what were you doing at Lefty's liquor store last Saturday night?" Smirk stated, "All right, man, I was there during the robbery." Then Officer Eckert placed Smirk under arrest and charged him with robbery. Smirk was taken to police headquarters where he was booked. For the first time, he was given his Miranda rights. He then waived his rights and confessed to being an accessory during the liquor store robbery. Afterwards, the judge appointed an attorney to represent Smirk. The attorney requested that both statements Smirk made to the police be not allowed into evidence. The trial judge granted the motion with respect to the first statement. Smirk's attorney now requests to prevent the introduction of the second statement given at police headquarters into evidence. Should the request be granted, denied, and why? A, B, C, D. Oh, there are a lot of you. Looks like we have mostly D, Delta. So Stella, why don't you tell me why you think it's D?
I thought it was D because he offered the second statement after knowing his Miranda rights. I don't think that the first statement, when he admitted, first when the cop just grabbed his arm, would be admissible in court because he wasn't read his Miranda rights. But the second one was after he looked at his Miranda waiver.
Yep, that is exactly correct. So he was read his Miranda rights. He was in custody. He was being interrogated, so Miranda would apply. He knowingly and voluntarily waived them. So anything he says after that is admissible. So he is, it's D. It's not too complicated of a question, so it doesn't require a big, long explanation.
Okay, I don't see any questions on that one, so we can move on to number 19. Herman was a senior pre-med student at Slippery Rock University. Before a big football game with a rival Transylvania Tech, Herman attended a prep rally at the university football field. During the prep rally, the students drank beer, sang songs, and gave each other cheers. As the rally ended, Herman was walking toward his car when he felt the need to urinate. So he strutted across the street to a municipal park and urinated against a tree. In this city, urinating in public is a misdemeanor. Unknown to Herman, a meter maid who was ticketing cars in the area witnessed the incident and wrote down the license number of his car as he drove off. She immediately gave the information to the police, who did a DMV check and learned his identity and home address. Within the hour, the police went to his house and forcibly entered the dwelling without a warrant. While searching his home, they found him studying in an upstairs bedroom. After giving him his Miranda rights, he confessed to the crime. He's prosecuted for the misdemeanor of urinating in public. If he requests his statement made to police when he was apprehended not be allowed into evidence, the request should be granted or denied. A, B, C, D. I'm getting a lot of D's. So Mackenzie, George, do you want to unmute and tell me why you think it's D?
Sure. So basically, since they didn't have a search warrant, they can't search his house, and they forcibly entered his house without a search warrant. And even though he did receive his Miranda warnings, they didn't have a search warrant to enter his house, and they forcibly entered it. And I think that's why it should be granted.
Okay, Mackenzie, you're absolutely right. The forcible entry and search by the police of his home was illegal since it did not obtain a warrant when the law required them to do so. So as a result of their illegal warrantless search of the home, his confession would be properly executed under the fruit of the poisonous tree doctrine. You're absolutely right. So you guys are doing really, and a lot of people got this right. So you guys are doing really well with this material. Do you want to do the last one, Lexi?
Sure. Last question. On Tuesday, the Riverside Police Department received info from a reliable informant that Keller would be extorting money from Gelson on Friday. The informant gave the police explicit details about the extortion scheme. The informant said that Keller would be calling Gelson from a public phone booth on the corner of Grove and Spring Street at 3 p.m. on Friday afternoon to make the extortionist demand. Without notifying the telephone company of seeking a warrant, the Riverside Police installed an eavesdropping device on the public phone. At 3 p.m. on Friday, Keller telephoned Gelson from the telephone booth and said, "You better pay me $5,000 by next Wednesday or I'll kill you and your family." Keller provided additional details about how and where to make the payoff. Based on the taped conversation, the police arrested Keller and charged him with extortion. Prior to trial, Keller's attorney requested to disallow the taped conversation to come into evidence. Should the defense's motion be granted or denied, and why? We've got some D, we've got some B. It looks like we have a good mix between D and B. So let's see here. Isaiah, do you want to tell me why you picked D, Delta?
Sure, but can I have like 20 seconds just to like read this thing again? Because I just, yeah.
Sure, we'll have someone pick B first and then we'll come back to you.
Okay, thanks.
Yep. See here, who picked B that wants to talk? I'm sorry if I say your name wrong. Yasmin? Do you want to tell me why you picked Bravo?
Can you hear me?
Yes.
You said it correctly.
Thank you.
I picked B because when they were calling, they received it, but since it's confidential because the telephone company, they didn't get granted the warrant. It should be granted that they take it out because they didn't receive.
Right. So did you pick B because they didn't get the okay from the telephone company or because the police didn't get a warrant? Because you mentioned a warrant. I just want to make sure I'm following you.
No, they didn't get approval from the telephone company.
Okay. All right. Okay. Isaiah, are you good to go on D?
Okay, yeah, I'm ready now.
All right.
So, okay, the reason I picked D was because when I was thinking about it, and like they said they installed the eavesdropping device based on the informant's information, it didn't make sense to me that the police would need approval from the telephone company to install the device, because I mean it's a subject of high interest for the police because like it's extortion, it's a big crime, and the informant gave them reliable information. So I feel like they would need a warrant, if anything, for that instead of approval from the telephone company. Because yeah, I don't feel like the telephone company would need to approve that. So yeah, that's why.
Okay. So the correct answer is A. It should be the defense's motion to exclude the taped conversation should be granted because the police did not secure a warrant before installing the eavesdropping device. So both of our volunteers had the correct idea, but picked the wrong answer. So anytime, any place that you have a reasonable expectation of privacy in is protected by the Fourth Amendment against unreasonable searches and seizures. A telephone booth, actually, I don't even know if you guys know what telephone booths look like, but a telephone booth has a door. It's got 4 walls on it. It's enclosed. You have a reasonable expectation of privacy in that phone booth. It's different than just talking on your cell phone outside, walking around on the sidewalk. You do not have a reasonable expectation of privacy there because you're outside, there's no enclosure, whatever. But in a phone booth, you do have an expectation of privacy. So because the expectation of privacy is there, the Fourth Amendment applies. And because the Fourth Amendment applies, the police need to get a warrant from a neutral judge before installing the eavesdropping device. Whether or not the telephone company approves it doesn't matter. The telephone company could say absolutely not. But if the judge okays the police to install that eavesdropping device, the police can still install it legally. Does anyone have any questions on why 20's answer is A? Okay.
Okay, I don't see any either. So that was the homework for this week. Overall, based on what you guys put in chat, I think that you guys did pretty well. So, oh, there is a question on number 20. Sorry, Lexi.
It just came up. I was gonna type an answer. So to answer Mira's question, if the person he's calling consents to the recording, is it okay? The answer, like all questions in law, is it depends. It depends on if the state that you are in is a one-party consent state or a two-party consent state. If it is a one-party consent state, which means that only one person on the call has to okay it to be recorded, then yeah, that's okay. You don't need the tap then. But if it's a two-party consent state, you would need the consent of Keller and Gelson. So just Gelson consenting would not be okay.
Okay, that's right. So I wanted you guys to work with this material so that you start thinking like lawyers and reading fact patterns and starting to digest that information and seeing what you learned could apply and how to apply it, because you guys are going to be getting facts like these stories, and you're going to have to find out which facts are the most important. We call that issue spotting. Find how things apply to what you're doing so that you know what questions to ask during trial and what arguments to make, and what I know you guys went over theories of a case and stuff last week. So the way to do all of that is just to start thinking like lawyers and think like what would apply and what wouldn't apply. So overall, I feel like I'm very proud of all of you. You did really well. So if you have any general questions, we're happy to answer them. But this week was just to have, and I think that you guys got the charges. So if you want to talk about the charges for your mock trial case, we can talk about what you would have charged and based on the statutes we gave you, or we can just talk about why what is being charged. Otherwise, it's just about 1 p.m. and that's the end of class time. So if you want to talk about the case, and we're happy to stick around. If otherwise, you're
free to go. Yeah. I think Felicia's cat is okay. They just like to talk.
Thank you. Okay, so Tyler, yes, and I kept trying to shoo him away, but he's loud. He likes attention. So when you ignore him, he gets louder. So he's fine.
I have one question.
Sure.
So I didn't get an email about the mock trial and like who my the co-counsel person is. Will I be getting that soon or no?
You should have gotten it either yesterday or the day before.
It was sent out today.
Today?
Oh,
Yeah,
I
guess
didn't.
it was.
I didn't get it. I didn't get it.
Check your spam and deleted box.
Okay. I'll check 1 minute.
I also thank you for class.
Thanks.
Thanks, guys.
Let's see. The mock trial cases that you're getting it was a real case, and it had come before the trial by peers program a few years back. So moving forward, the cases you would get would be real cases. We call it mock trial because at the end of the summer class, you'll be going through a trial, and that is a mock trial since you're not putting on an actual trial at this point. That's why we use the word mock, because it's from an old case. How do you?
Sorry.
Go ahead. No, I'm just reading the questions. How do you interview the person? You mean like for questioning? Genevieve? Okay, we're going to go over direct examination and cross-examination in the 4th week of class. So that would explain how, because you're going to do it differently when they're your witness versus the other side's witness. When they're your witnesses, you do what I'm going to spoil week 4, but you do what we call open-ended questions. And then when it's the other side's witness, you do yes or no questions. There are 4 weeks total of homework. We're taking a break, I think, next week for 4th of July.
Reply to people. I'm just gonna talk.
Yeah.
Catherine, there should be on the top of like where the names are, it will say like set C1, set C2, set D1, set D2. That's how you know which group you're in.
I checked my email and I didn't find it in spam or trash.
Send an email to Katya and let her know that you didn't get it so that she can send it to you.
Okay, thank you.
And all the info for your co-counsel, your opposing counsel, and who your witnesses are will be in that email that Katya sent out this morning, or that Patrick sent out this morning. I'm sorry.
Oh, okay. Was it already sent?
It was sent at like 10:30 this morning. Yeah.
Oh, I didn't get that one either.
Yeah, Mackenzie, if you didn't receive it, go ahead and send us an email.
Okay.
And then, but please do check your spam or trash, whatever it may be. But also, if you received the homework, it's the same email that we're using. So if you received all the other materials this week, that is the same email we're using.
Okay, thank you.
Aren't we supposed to start prepping this week for the mock trial?
You should be reading through the materials and making, so that there was a question about witnesses. How would they know what's going to be the answer if they didn't actually witness it? You're going to learn it from the materials you were given. So you were given a set of facts. So we would work inside those facts. So whatever that witness says that they learned, you want to start reading that stuff so you know what to say.
Excuse me?
Yep.
I'm the prosecutor on one of them, but the defense is my sister. Is that okay, or do we need a change?
That is a question for Katya and Patrick.
That is completely fine. You're the prosecution in this defense. I did that purposely. So
Okay. So it's okay?
yeah, it's fine.
Okay, thank you.
For mock
And
trial, it's
also,
okay.
I need to change
Yeah,
my
obviously for
contract.
mock trial, that is okay. But in real cases, no.
Okay, thank you.
If you need to change your contact info, Kaden, just email Katya again or reply back to the email that got sent out at like 10:30, and they can send out like an updated sheet.
Okay, thank you.
And then attendance today was emailing Katya with a fun fact about yourself. If Mia's still on. Oh yeah, she is. Okay. I think that's it.
Go ahead, Caleb.
Okay, can you hear me?
Yep.
Okay, so for question 3 on the homework, I was still very confused. And no, was not question 3. Question 4. With the mayhem and battery, I still didn't understand why it was mayhem, because I looked up NRS statute and it said if a defendant disfigures a part of a victim's body, and that it's considered mayhem, and I didn't understand why that wasn't like correct in this case.
So disfiguring, it does not include like a cut on the lip, even if it's a deep cut. Like disfiguring would be like really maiming like a limb, or like if you ran over someone's face with your car, that would be disfiguring or not dismembering. You really have to mess someone's body up for it to be disfigurement.
So it would have to be like missing a limb, missing a finger, like a giant scar down your face, something more than the gash in the lip, basically.
Okay. That makes sense. Okay, thank you.
Mm-hmm.
I just sent out an email to Kathia and Patrick. So so that'll fix it, right?
Yes, they'll fix it. I saw something came through, so we'll get to it.
Okay, thank you so much. Bye.
You're welcome. Well, if there's nothing else, we could, there's only 12 people left on the call, so.
I think the only question left was the question about just reading over the materials for next week. We're not doing a formal class for the 4th of July weekend.
Right. No class. So we skip 1 week and then we go into the following week.
Yep. So Mia, same time on the 10th, just not the 3rd.
They should have a schedule when we first email, but we'll send out another schedule to them with all the classes.
You're right, Aaron. No homework either.